Hi, this assignment is on private placement, term sheet, due diligence, and regulation. It's by James Peel. For most new businesses, one of the biggest challenges the founders face is keeping a steady stream of funding to keep the business on its feet. One way to raise capital is with private placement of equity in the business. Part of this private placement process involves giving potential investors what is known as a private placement memorandum, or PPM. Veterans of the venture capital field say that this document is the second most important for new businesses after the initial business plan. Essentially, the function of a PPM is to inform potential investors of the risks associated with the business. This is extremely important because there is always the real possibility that the new venture will not be successful, and the PPM gives the entrepreneur some degree of legal protection. To ensure that the PPM gives the entrepreneur adequate legal protection, it is often written along with an attorney. Before we discuss the details of private placement memorandums, let's first look at why a business would opt for the private placement of securities over a public offering. The most obvious reason for this is money. The public offering of stock can be a very complicated and expensive process, which requires heavy involvement from the SEC and countless laws and regulations to abide by. Many new companies simply do not have the resources for this kind of offering, so they find that private placement suits them better. However, there are still requirements for private placement to be exempt from many SEC regulations. The new stock may not be advertised publicly, and it is still required for the company's financial records to be available to potential investors. This is where the PPM comes in. One of the most important parts of a private equity offering is the term sheet. The term sheet acts as a sort of rule book that outlines all of the terms, conditions, and warranties for the transaction. The term sheet usually isn't legally binding, but it acts as a framework for the actual deal. After the term sheet is agreed upon by both parties, it starts to take the form of an actual legally binding deal. Another crucial step in the process is to make sure that all risks are made very clear to potential investors. While the purpose of the document itself is to present potential investors with the opportunity to invest in your company, the purpose of the risk section is to ensure that investors know of any reason why they would not want to invest in your company. While this may sound counterproductive, it serves the purpose of preventing investors in the business from suing the entrepreneur in the event that the business is a failure. This means that this document isn't a sales pitch as much as it is a factual outline of the state of the company so investors can make an informed decision about whether or not and how much to invest. Potential investors need to know any and all issues that the company might have, which means going into specific detail. The more potential investors know about the company, the less likely they'll be able to sue if something happens in the future. The best strategy to accomplish this is to go through the company's financial statements piece by piece and look for anything that could possibly be a problem and if any of those numbers are particularly sensitive to market conditions. The key to writing an effective PPM is to make sure that everything about the company is as transparent as possible so investors can be confident that they're making a smart decision. Perhaps the biggest roadblock to any kind of business transaction is the SEC. Since the SEC's purpose is to ensure that business practices are carried out honestly and responsibly, they set up countless regulations on every type of transaction, including private placement. Aside from the federal government, each state has different requirements to issue equity that the entrepreneur needs to be aware of. In the case of the SEC, offerings of equity securities are usually subject to Regulation D, which requires that the offering be registered with the SEC. Small private placement offerings are exempt from this regulation, but they must first file a document known as Form D with the SEC in order to make it official. This form must include basic information about the company and its executive officers, and details about the offering itself, such as the size of the offering and how many potential investors it is offered to. The concept of due diligence is something that can be very abstract and confusing, but in the case of most PPMs, the appropriate information that the investors need to ensure due diligence is listed in the document. Typical information includes articles of incorporation and bylaws, any past issuance of securities, proof that all state laws have been abided by, information about all current shareholders, any contracts the business is involved in, any tangible or intangible assets the business may have, detailed description of operations, and summaries of any past government reviews or audits. Organizing the due diligence process in such a way takes the guesswork out of what information the company needs to provide potential investors with. Out of all the items on this list, the ones that potential investors are most concerned with are the accurate and complete financial statements of the company. This includes not only information about past performance, but realistic projections about future performance as well. After all, the main concern potential investors have is with the company is how the value of their investment will grow over time. In order to determine how much money to ask for how much equity, a few factors have to be taken into consideration. First, the company needs to decide how much capital it is trying to raise. The tricky part after this is to determine how much equity investors will likely want in return for this amount of capital to receive the IRR that they are looking for. This involves establishing a fair value for the entire company. To establish this value, the company needs to have a realistic and trustworthy system to predict future cash flows. The values that investors are most concerned with are typically the current EBITDA, projected EBITDA at the end of a given investment period, how much equity is being issued, and how much is value at, the expected dividends this equity will pay, and how the typical firm in this industry is valued in relation to EBITDA, and how much debt and cash the firm is projected to have at the end of the investment period. Once the enterprise value is established by comparing the EBITDA to the rest of the industry, the company can determine how much equity they need to give up to raise the target amount of capital. This then decides the pricing of the new securities. Potential investors can then use the projected financial statements to decide if their required IRR will be met. That was my PowerPoint presentation, and thank you for watching.